Mr. Blackman, let's follow up on the discussion we just had. If a president can unilaterally suspend immigration laws for at least 4 million people by using the discretion that's almost always granted of prosecutorial discretion, meaning the hard case, the tough case, you have discretion about whether or not to pursue that case. If that can be taken to swallow up the law by granting prosecutorial discretion and suspension of the laws for 4 million people, what limiting principle could stop the president from granting, for example, capital gains tax amnesty to the almost 3 million households who make more than $250,000 a year?
So this is the million-dollar question that the government does not like answering. What is the limiting principle? Sir, the short answer is there is none, right? If the argument is, due to Congress's lack of resources, I can't enforce every action, and I'm going to simply prioritize, the president can say, instead of going after capital gains tax, I'm going to go after people who don't file tax returns at all. I can't go after everyone. This is a category of people that I don't deem particularly dangerous. Much worse is people don't file any returns. There isn't. Indeed, the Attorney General's argument with respect to the deferred action for immigration doesn't have much of a limiting principle. The fact that the president chose people without criminal backgrounds and people who are generally upstanding human beings is nice, but that doesn't have to be the answer. What we effectively have here is a very dangerous slippery slope. And if I may respond to a point my friend Mr. Lazarus made, this is a job for Congress. When I'm writing briefs, I'll make arguments for the courts, but fortunately here I'm today talking to Congress. This body needs to reassert itself in the separation of powers. And if it actually views the president taking these actions, they should do something about it. The mere fact that past presidents have done stuff and Congress can object does not make it constitutional, right? This is like when your kid starts jumping up and down the bed. You say, stop it, stop it, stop it. And you say, well, Daddy, I've done this before, right? That doesn't necessarily make it right. Past practice is helpful, but it does not by itself render it constitutional. And I think this body has a duty to try and reassert itself.
So the correct answer is, if the president says, well, I don't know what the limit of prosecutorial discretion is, I think it could include 4 or 5 million people, the response of the court at the case that's now on its doorstep, and the court has said we want to also look at the question. They asked the parties to brief the question of what the take care clause provision means to this case. The response of the court should be, if you're not sure what that limit is, you shouldn't come to us, the United States Supreme Court. You should go to the United States Congress, because the Congress under Article 1 writes the laws. And if you're uncertain about the limit of that law, you should go back to Congress for direction on that, not come to the court. Is that?
Absolutely. Yes, sir. I mean, in the Obamacare case in 2012, which the government won, they could identify a limiting principle in the commerce power. And the court said, you know what, if you won't draw a line, we'll draw it for you. I will be very pleased if the court takes up the take care issue and actually writes about this, because indeed the president has not seen fit to have any sort of line of what he can and cannot accomplish through the prosecutorial discretion.
Ms. Pepez, taking a step back from that individual case, what do you think are the best reforms for us on this task force to consider that would restore the role of Congress as originally understood?
Well, you know, it's a hard question. I think there are several tools at the body's disposal that, could be brought to bear in light of some of the recent court decisions. I think something like the ACA illustrates the difficulty. I would imagine there are many in Congress who thought that the provision that the Supreme Court found ambiguous was indeed clear. So I think part of the job is going to be looking at some of these decisions and saying, what can we do differently going forward as a legislative matter, number one. But the second piece is the power of the purse, right, and the spending power. I think that's an area where there's really no debate. Both sides of the aisle would agree that that power is constitutionally vested in the Congress. And so making appropriations very clear and using the oversight process to discipline executive branch spending and budgetary decisions is another powerful way to do it. Because again, if there's a debate about how the legislation, what it means or how it was written, and there's not going to be, a process of coming back to the body to revise the statute, the one way that I think Congress can and perhaps should compel that is with the power of the purse.
Thank you. Ms. Slattery, you want to comment on that as well?
Thank you for the opportunity. Thank you for the
It's
opportunity.
flattery. Thank you.
Oh, I'm sorry, okay.
Flattery will get you nowhere.
I would say an important first step is changing the culture in Congress by holding hearings like this one, getting out of the habit of delegating broad amounts of authority to unaccountable agencies, by not pinning their hopes on the courts to resolve problems with the executive branch, and using the tools that Ms. Pepez also mentioned.
Thank you very much. Thank you, Mr. Chairman.